Hi, everyone, again. Welcome back to some GOPO lessons. We're going to go over chapter 3 now, which will be talking about federalism. So, I'm going to do a brief recap of what that is with my super technical post it note. Okay. So, when I talked in chapter 2 about how a power can be divided between the national and the state governments, the UK had unitary, which meant that all the powers were the national government, and we wanted nothing to do with that when we made the our country's first form of government. We wanted to be the exact opposite, so created a confederation, which is where the state and local governments have all the power, and there's really no power at the national level. And remember, the Articles of Confederation were weak sauce. So after that, when we made the Constitution, we realized that that was a much better idea. James Madison said, let's have that happy combination where the states and the local government share power, which is federalism. Okay. But obviously, it doesn't, not every system is perfect. So we're going to look at some of the conflicts that the states and the national government have with each other. So what I'm going to do is in the first section, I'm going to basically show you a modern day example of when we see state governments and the national government fight with each other over different things. And this is going to be over medical marijuana. So we have to consider things when we're looking at who has power, the state governments or the national government. Where are the boundaries between the powers of the federal government and those states? It's very arbitrary. It's so, and government is so complex, and the Constitution is so vague that it's hard to figure out where those lines are drawn. When the framers were trying to figure out this answer, they had to look at a couple things. They realized the states could not be sovereign. They could not have their own powers like a country would have their powers. They tried that with the Articles of Confederation, did not work, so they needed to do something else. But they also realized the national government shouldn't have all the power. They don't know what's best for every single state. And when they saw that with England, they hated it. They realized it just wasn't right for our political culture. So they divided the authority with the goal that there wouldn't be tyranny at the national level, but states would have some autonomy, but they would not be sovereign. But there's constant conflict over state versus national authority. And the modern day example is this with the conflict over medical marijuana, but not only medical marijuana, but the use of marijuana, especially nowadays, because many states like Illinois, for instance, has legalized recreational use of marijuana. But here's an example of one where the Supreme Court had to get involved, because anytime there's a dispute between the national government and the state governments, the Supreme Court or the courts itself are the ones that are going to get involved, especially the Supreme Court. So here's what happens. Whatever they choose to decide, one thing or another is going to happen. It can't be both. If they decide option A to expand the national power, it takes power away from the state governments. But if they give power to the state governments, it's going to take away power from the national government. They can't go up and down at the same time. They have an inverse relationship. So one court case that was like this was the court case of Gonzalez versus Rake, which was in 2012. What happened was two people filed a lawsuit in California federal court against the U.S. government, and they did this. Gonzalez was the the Attorney General of the United States at the time, so that's who they were suing. They were upset because they had severe health issues and they grew marijuana and used it for medicinal purposes, but they got in trouble for it by the DEA. Why? Because since 1970, marijuana at a federal level has been considered illegal. But in 1996, California passed an act that said medicinal marijuana use was legal. So any state, and the 1970 Controlled Substance Act has been in play, and it's not been found unconstitutional. It's not been revoked, nothing. It is still in existence today. It is illegal to use drugs like marijuana. Yet, so many states have made laws that allow not only medical use of it, but recreational use of this. So how is this happening? I mean, could the federal government come in and say, you guys can't do this, it's over? Absolutely. Will they? I don't know. It's just kind of like they're supposed to be enforcing the law, and in this case they choose not to. A lot of times when it comes to situations like this, they kind of have a wait back and see what happens, and that's kind of what's going on right now. I'm going to skip this because I want to go on to the next section of federalism and the Constitution. Where do we see federalism set up in the Constitution? That's what this section's about. So now this is like a little bit more graphic. I personally like this better, but it's showing you the same thing, which is basically that the national government gives the powers to the states in a unitary system. They share the powers in a federal system, and the state governments were the ones that gave the national power to in a confederacy. But we have that happy combination in the middle of federalism. Most countries in the world use unitary. Lots of different countries use federalism, but we came up with it first. So federalism divides power among the layers of government, not just at the national level, but even at the state and even the local levels. But there's lots of conflict between those who have power to legislate on these public policy areas, just like I showed you with the marijuana situation. Now, the Constitution provides the national government power through the articles, meaning like Articles 1, 2, and 3 in the Constitution. But then they basically say with the fourth article in the 10th Amendment, anything that is not given directly or delegated to the national government, the states have those powers. They're reserved to the states, so they're called reserve powers. So here's what we need to consider with the national government. What powers are constitutionally given to the national or federal government, and what's reserved to the states? So which ones, what do they get? Well, where we find this is in Article 1. Article 1, Section 8, we're going to find enumerated powers or express powers. They mean the same thing. Those are the powers that are directly given to Congress in the Constitution. This is in Article 1, Section 8. Now, if you see exclusive powers, those are only the national government exercise. I'll give you the easiest example. They can declare war. Okay, Illinois cannot declare war on Wisconsin. Minnesota cannot declare war on Canada. It just can't happen. That's exclusive to the national government. But they also have something in Article 1, Section 8, Clause 18. They have this thing called the elastic clause or the necessary and proper clause. And that gives them implied powers. It basically says, well, if you feel, Congress, that you need to make a law or do something that's necessary and proper for the country, you're allowed to do so based on your expressed or enumerated powers. Probably the best example of that is that one of the expressed powers that they have is they can provide an army and a navy. So that says it word for in the Constitution. Back then, they didn't have airplanes or rocket ships, so they didn't put anything in there about an Air Force or a Space Force. So that's how they've stretched their powers. That's why it's the elastic clause, to give them an Air Force and a Space Force because they felt it was necessary. This is just an example. They're showing you the Air Force right here. The creation of this was based on the implied powers that they could expand the military to include that. A few other national powers that they have in here. The Commerce Clause, this is a big one. This is one they use a lot. It grants Congress the power to regulate commerce with other commerce is trade, with foreign countries, between states, and with Indian tribes. So they've actually really, especially with the John Marshall Court in the 1800s, really expanded that rule to mean like they have really any power over business transactions, which is a lot. Like I said before, the necessary and proper clause or the elastic clause is the one that says, well, if they feel it's necessary and proper, they can stretch their powers and create more. Probably the first real use of that you guys would remember from U.S. history or APUSH, whichever you took, would be when Alexander Hamilton created the National Bank. It does not say anywhere in the Constitution that Congress and the national government can create a national bank, but they felt it was necessary and proper. And since they can levy taxes, it says that word for word in the Constitution, and they can coin money, they kind of like felt it was necessary and use those as their basis for the rationale for it. And then the Supremacy Clause says this: the Constitution and the laws of the United States are the supreme law of the land. So that means that whatever they decide is it. If there's ever a conflict between the state government and the national governments, basically the national government is going to win every time. That's the supremacy clause. So what do the states get? It's very vague what they get. It's basically like you get the leftovers. I see the reserve powers as the leftover powers. Anything we don't have for ourselves or isn't denied to government, specifically in the Constitution, you guys get. So what are some of those? Well, I would say the easiest ones to do would be like speed limits, education laws, you creating national or local governments, and what's the other one? Oh, administering elections. We're a state that is giving the day off for the presidential election, where other states don't do that. Any state can decide how they want to do that. But then there's also powers that are concurrent. It means that the government at the national level and states can both do these things. And here are the greatest examples. They can both create their own courts. There's national courts, there's state and local courts. They can enforce taxes. They can borrow money. Those are all examples. This chart right here is an excellent one to have, where you can see the labeling of the types of powers, examples of federal, state, and shared. And then these are things that are denied to the people. And I'm going to tell you this. One of the things that's denied to the federal government is they can't grant titles of nobility. If I ever become president of the United States, I'm bringing that back. So let me know if you want to get on my list to be knighted or become a lord or lady. All right, let's look at the regional and local governments again. We're going to look at those. And as they have conflicts not only with the national government, they could have conflicts with each other. So Article 4 set it up and basically said, here's what the states have to do with each other. So it keeps conflicts from happening among the states as well. In Article 4, there's 3 parts to it. The first part is the full faith and credit clause, which basically says that states have to recognize the acts, records, and proceedings from other states. So, for instance, if you have a driver's license from Illinois and you're driving through Iowa and you get pulled over and they ask for your license, they have to give full faith and credit that that's a legit license, even though it's not from Iowa. Extradition is the requirement that a state has to return a fugitive from another state. So if I murdered my husband, I'm not going to, but if I did, and I did that here and I ran away to Missouri, it would be the responsibility of Missouri to return me to Illinois. And the governor is the one in charge of doing that. They have to do that. If I ran away to Canada, they wouldn't have to necessarily return me because we can't. They're their own sovereign state. They can decide what they do. A great example of this happening in real life is Edward Snowden, the guy who worked for the NSA that committed treason by revealing top secret information by the government. He ran away to China and to Russia, and both of those countries are not extraditing him because they're not really big fans of us. The third one is the Privileges and Immunity Clause. That one prevents states from discriminating against people from outside the state. So, like, for instance, there's exceptions to the rule, but some examples of where they can't do that is you can go and live in a state, you can buy property in a state, you can drive through a state, and they can't stop you from doing that. But a great example that probably some of you are noticing is that if you go to an out-of-state school, they can charge you higher tuition. That's an example of like a way they can discriminate against you if you don't live in that state. All right, so that's it. Tomorrow or the next time we look at notes, I'm going to talk about the nature of federalism and how it all kind of flows together. For now, I am done. Have a good day. I will see you guys later.